He's muted.
You're muted, Mr. McElroy. Can you unmute yourself?
Yep. Can you hear me now?
Yes, thank you. All right, so we'll go back on the record in People versus McElroy. This is file number 255128. Both counsel are present here in the courtroom. Mr. McElroy is present by Zoom video. Mr. Horowitz, were we able to reach an agreement?
Yes, Your Honor. And just before we proceed, I just have to tell Mr. McElroy that Mr. Ziegler did concur with my guidelines estimate.
Okay, so the 0 to 11 standard.
That's our approximation. We can't guarantee that will ultimately be the number, but that's based on our calculation of assessment.
Okay.
Your Honor, Mr. McElroy will be entering a plea. The charge would be a reduced charge of possession of analogs, and and that the habitual enhancements will be dismissed. Additionally, if people agree to recommend a sentence within the guidelines.
What is the maximum penalty for the possession of analogs charge?
Yeah, it's a 2-year felony, Your Honor. 2-year high court misdemeanor.
Okay, so that's gonna be an added count too.
Correct.
All right, thank you. Mr. McElroy, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, sir.
Okay. Can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. McElroy, as Mr. Ziegler just stated, the maximum possible penalty that you could face for this different charge of possession of analogs is up to 2 years in jail or prison. Do you understand that?
Yes, sir.
Are you currently on any kind of probation or parole?
No, I have a, no.
Okay. With that maximum possible penalty in mind, then what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates that this happened back on September 22nd of 2025. Is that the correct time frame?
It actually happened on August 6th.
Okay, of 2025.
Yes, sir.
At that time, were you present here in Kalkaska County?
Yes, I was. I was at Freedom Park in Rapid City.
All right, and did you have possession of some heroin or fentanyl at that time?
Yeah, I had a burnt residue in my pocket.
Okay. Did you have any legal right to possess any amount of that substance at that time?
No.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
We are, Your Honor. Mr. McElroy is correct about the date. I was going to amend that before trial if we had gotten to that point.
Okay. Mr. Horowitz, are you satisfied with the factual basis?
I am, Your Honor. Thank you.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor, I would just state that I did calculate and Mr. Ziegler confirmed to an extent that I estimated Mr. McElroy's guidelines at 0 to 11 as on the high end. And I only state that it's not a promise by any means, but just for the record, that could be considered an inducement, I guess.
Okay. And counsel, are both of you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. McElroy, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Prior to that, someone from probation will be in touch with you to prepare a pre-sentence report. You'll have an opportunity to go through that with your attorney prior to the sentencing hearing. Mr. Horowitz, is there anything else that we need to address for the record here today?
Not really. I'll take it up with the precedence report author. There may be some complications in accounting for Mr. McElroy's time because of other cases that were going on around.
Okay. Mr. Ziegler, anything further from your side?
No, Your Honor.
Mr. McElroy, do you have any questions about how we're going to proceed with your case?
I don't believe so. Like my sentencing's probably about 30 days out, and the only other thing that, you know, that's probably not even a possibility, but I had mentioned the bond situation being $20,000, you know, if there was any way that that could be dropped down, but I'm probably going to get jail time anyway, so it might not matter. But I mean, the bond's completely unreasonable at 20 grand. I figured, you know, if I want to try to get some things straight before I get sentenced.
Okay. At this point, based on the plea today, the court is not inclined to grant a modification of bond. So we'll go forward to the sentencing hearing. And you're correct, it will be in about 30 days.
Okay, thank you.
Okay. All right, that's all for this hearing today, and the court is going to disconnect at this time. Looks like we've got everybody connected. So we'll go on the record in file number 2511839, the estate of Smith versus William Smith. And we have Mr. Isles on behalf of plaintiff present here in the courtroom. I see Mr. Giroux connected by Zoom on behalf of plaintiff and Mr. Lobello on behalf of defendant. This is set for hearing today on plaintiff's motion for summary disposition. I did have an opportunity to review the briefs of both sides, as well as I read through all the deposition testimony that was submitted and all the other exhibits. So I'm familiar with the facts of what happened here and the arguments of the parties. Mr. Isles, did you or Mr. Giroux want to handle our?
Mr. Giroux is going to do that today, Your Honor.
Okay, so Mr. Giroux, is there anything you wanted to state by way of oral argument in support of your motion?
Good afternoon, Your Honor. And I don't believe so. If this court received on Monday our reply, which was basically all the rebuttal arguments, and was able to see the affidavit of the witness and I think the court indicated it did read the testimony of the defense expert and the trooper who did the accident investigation and reconstruction. I don't have anything to add to all of that. I'm sure the court noted all of the testimony and the evidence and the proofs. I would just like an opportunity to respond to anything that defense counsel has to say, but that would be very brief.
All right, thank you. Mr. Lobello?
Your Honor, I believe our brief also covers all the arguments made by the plaintiff. Just to add briefly, I believe this is a matter of weight and credibility. With regard to the deposition testimony and Mr. Smith's statements. In addition, Your Honor, there doesn't appear to be any authority provided by the plaintiffs with regard to their intent to seek a claim under the No Fault Act. I believe that the Hardy case covers that issue in detail. And with that, Your Honor, I would submit to any questions that the court might have. or respond to Mr. Giroux's arguments if need be.
All right, I guess, Mr. Giroux, I did have one question on that issue of the complaint. So I mean, I reviewed the complaint. It doesn't cite either the Wrongful Death Act or the No Fault Act. It's pled as a claim for negligence.
Yes, it is a claim for negligence, Your Honor.
Yeah, so my question, and looking at MCL 500.31352A, which is the provision that you cited in your motion, you're in asking the court to find summary disposition that your client is entitled to no non-economic damages under the No Fault Act. When I read that provision, to me, 3135-2A deals with the court's determination, either a question of law or a question of fact, as to whether or not a plaintiff has suffered a serious impairment or a permanent serious disfigurement. In this case, we're dealing with somebody who suffered death. So to me, it's really irrelevant. That provision 2A is irrelevant because we're not dealing with whether or not there's a question of fact on an injury here and whether it qualifies for non-economic benefits. So I guess I don't understand fully what your argument is. And in any case, that provision wouldn't call for a finding that a plaintiff is entitled to non-economic damages. It would just be a finding that as a matter of law, there's no question that they've suffered an injury that would qualify for those kind of damages under the statute. So can you clarify for me exactly what you're asking for there?
Yes, Your Honor. Again, the reason we pointed that out in the law is because historically, prior to the existence of the No Fault Act in the state of Michigan, obviously we were dealing with just a straight form of negligence law. And every party who felt that he or she was harmed by a breach of the ethical standard of care or a breach of ordinary care or failure to follow ordinary care, which is the definition of negligence in Michigan, they could file a negligence claim. Then comes the No Fault Act, and it basically is supposed to be an all-encompassing act, except under 3135, where it says, so the No Fault Act provides immunity for anybody who's driving his or her car that is insured. They complied with the law, they got their insurance. They're immune from many things. They're immune from being sued for wage loss, except for excess wage loss. They're immune from being sued for medical bills. They're immune from being sued for certain things that you could get in an ordinary negligence case. However, under 3135, a driver does not have immunity. They don't have that protection for any injured person who has suffered one of the threshold injuries. So that's the only purpose of citing that statute, is to say that the defendant is immune from certain types of damages, including medical bills, everything that's covered by the No Fault Act. We could not sue the defendant for and have not. We can sue, and you have to look at both statutes, 3135 and the Michigan Wrongful Death Statute, when you get to the damages portion of this case. Some of the damages under the Wrongful Death Act we are allowed to get, because you have to look at both statutes in conjunction. Some of them we are not allowed to get. And so that is the only point of that citation or that statutory reference, which is that the defendant does not enjoy total immunity. The defendant only enjoys immunity for those things that are covered under the No Fault Act. And he doesn't enjoy immunity because the decedent suffered, or the injured party suffered, one of the three identified threshold injuries. That is all, Your Honor.
Yeah, so I still don't know what you're asking me to rule on today, though, because it seems obvious that your client suffered death, so your client has suffered one of the threshold injuries.
Yes, so we're asking you to rule on the negligence portion of our claim that's identified in the lawsuit, and the liability portion of that, which would be, did the defendant fail to act with ordinary care? More specifically, did he violate the statute that says you have to basically drive at a reasonable speed such that you're not driving too fast for conditions and lose control of your vehicle, which is a presumption of negligence, and also consider the fact that there are no available defenses to rebut the presumption of negligence, because not only did the state trooper testify unequivocally, this is not a sudden emergency case, which would be the only way to excuse a violation of the statute. he testified unequivocally this is not a sudden emergency case because the snow and ice had existed all morning and for many, many, many miles, and it hadn't changed. The defendant's own expert that the defendant's attorneys retained agreed and said, yeah, the only cause of the accident is that Mr. Smith, unfortunately, was going too fast for conditions, and that he could not identify any sort of sudden emergency that existed in this case. So then why would we go through, and the whole purpose of motions for summary disposition is to streamline cases like this. If there's no question of fact on a particular issue, why take up the court's time? Why take up the jury's time? Why not hone in on those things that actually are in contention? And here, even if the defendant's affidavit were available in paragraph 5, it clearly says that the icy conditions remained. And the definition, the plain definition in the dictionary is for remained as continues to exist. So over the course of case law in the state of Michigan, particularly on this issue, under a case like this where a driver is experiencing icy road conditions for many, many miles, there has never been a case that has upheld a defense like a sudden emergency because it's not sudden. It's well known. It was well experienced. And the only explanation in this case by all of the witnesses, fact witnesses and the and the expert witnesses, is that unfortunately the defendant made a mistake and was driving too fast for conditions because there's no other explanation for the crash. So we're trying to shorten up the trial. I'm trying to avoid repetition of testimony and factual recitations when the facts of the case are very straightforward and simple. And I think it would be just to grant this motion on the issue of the defendant's negligence, because there's no question of fact, and let the case go to the jury on the issue of damages, whether or not something else, I guess, was a proximate cause of Mrs. Smith's death, if that's what the defendant intends to do. But that wouldn't mean that Mr. Smith's negligence was also a proximate cause, because clearly it was. We submitted the death certificate, and no one has ever contended that the death is not directly related to the crash.
Okay, going back to my original question on the No Fault Act part of your motion, though, are you asking me to make some kind of ruling specifically under the No Fault Act?
No, Your Honor. We're just making sure that it's clear that the defendant doesn't enjoy that immunity as it relates to those particular damages that are allowed in this kind of case.
Okay, all right, thank you. Mr. Lobello, anything you wanted to say in response to what Mr. Caruso had to say?
Yes, Your Honor. And again, I think that perhaps the most instructive interpretation of the sudden emergency defense as it applies to this case comes from actually Mr. Jabrew's brief itself on page 15. One who suddenly finds himself in a place of danger and is required to act without time to consider the best means that may be adopted to avoid the impending danger is not guilty of negligence if he fails to adopt what subsequently and upon reflection may appear to have been a better method, unless the emergency in which he finds himself is brought about by his own negligence. Your Honor, the statement that we provided from Mr. Smith indicates that he adjusted his speed not once but twice, and simply because he adjusted his speed either not enough or not to whomever's standard it might have been necessary is for the jury to decide. But that fits squarely within the definition of the sudden emergency, is that in spite of Mr. Smith's reasonable care that he exercised prior to this incident, he was still unable to control the vehicle nonetheless due to the sudden icy conditions. It's been held in both the Young versus Flood case and the Marciano versus Booth case, as well as for the court's candor, upheld by the Court of Appeals as recent as 2022 in Cousineau versus Cousineau, and that's WL 17111-703, Michigan Court of Appeals, May 26th of 2022, that is a standard by which, that the icy conditions, even though existing for some time, may still present themselves suddenly in order to create the sudden emergency that we're claiming here in this case. So, Your Honor, again, I believe Mr. Smith's statements regarding his actions prior to the accident, in spite of however much the plaintiff's counsel may disagree with them, create a question of fact for the jury to decide in terms of whether or not his actions were reasonable prior to this accident occurring, and whether or not he was the proximate cause of that accident. And again, there's indication from Trooper Stone that the seatbelt did not lock in this case. And unfortunately, I just noticed this the other day, but Trooper Smith's deposition was taken on October 22nd, 2025. He was then listed as an expert by the plaintiffs on October 28th, 2025. So in terms of the basis for Trooper Stone's knowledge to be able to comment on the seatbelt issue or the airbag issue, I don't believe that those facts are in evidence to qualify him to do so, Your Honor. But again, that's a matter of admissibility of that issue as opposed to whether or not the court should rule as a matter of law whether Mr. Smith is at fault wholly for this accident.
All right, thank you. So again, I did have a chance to read through all the written materials. The arguments of counsel here today have been consistent with what they've submitted to the court in writing. As both counsel are aware, the court has to view all the facts in a light most favorable to the defendant as the non-moving party here. In order to grant summary disposition for plaintiffs on the issue of liability, the court would have to find that there's no genuine issue of material fact. In other words, that no reasonable juror could find in favor of the defendant. Looking at the case laws cited by the parties here, number one, the court finds that the parties are correct in their assertions under those cases that the jury can infer negligence if it finds that there's been a violation of a statute, whether that's a civil infraction or a criminal charge. And it seemed like all the opinions here in this case were that the defendant was driving too fast for conditions based on the data and the information available. So a jury, I think, could infer from that because the defendant was driving too fast for conditions, if they accept that opinion, that the defendant was negligent. But again, under those cases, that inference can be rebutted or removed by a situation where there's some type of acceptable or reasonable excuse for the violation of the statute. And one of those is the sudden emergency doctrine. And that requires that there be some type of unusual or unexpected condition. Unusual is defined by the cases as varying from everyday traffic conditions. Unexpected is a type of condition that appears so suddenly that normal expectations of due and ordinary care can be modified or disregarded because of the nature of that unexpected condition. And looking at the Young case and the Amick case, which both indicate that in Michigan, in the wintertime, snowy and icy conditions aren't necessarily unexpected or unusual. They persist for a large part of the year, particularly depending on what area of the state that you're in. And so that doesn't necessarily give rise to an unexpected or unusual condition just by virtue simply of roads being snow covered or having ice or generally wintry conditions, which can make driving hazardous. And that's, I think, kind of plaintiff's argument here is this isn't an unexpected or unusual condition. Defendant should have anticipated potential hazards and used due care, driven at a reasonable speed, given those conditions. And had he done that, this accident wouldn't have happened. But I think those cases also make clear that there's a distinction factually between the type of situation, I think, which was in existence in Young and to some degree in Amick, involving an assured clear distance type of violation where a person is following too close, hits a patch of ice, and slides into another vehicle, in which case in that situation, it's much more reasonable to expect that that person has to anticipate that something could happen in between when they start to brake and when they encounter the car in front of them. And they need to keep enough distance to take into account potential snowy or icy conditions. Versus a situation where a person hits a patch of ice and crosses the center line, and where a driver is going at reasonably prudent speed for conditions, but nonetheless still hits a patch of icy road and the car skids and crosses the center line and hits another vehicle, that could give rise to an unexpected or unusual condition, because even in those snowy conditions, that in and of itself wasn't expected. And depending on other factors, even in snowy and icy conditions, particular patches of black ice or so forth that cause a person to lose control, even though they're otherwise exercising due care for those conditions, could be a sudden emergency that would or could rebut that inference of a finding of negligence by violating the statute. So when I look at the specifics of this case and the testimony of the troopers here, I mean, they all kind of acknowledge that it's the default position that any accident that arises from a car sliding or skidding or losing control in snowy or icy conditions, their default position is that it's too fast for conditions. And that gets written up in every report. And it's not based on a specific, analysis of that particular accident. It's just kind of, we had a car slide, lose control, there's icy and snowy conditions. It gets written in the report as too fast for conditions. And Atkinson, in his deposition, even acknowledged that, hey, we put this in every report, but ultimately it's up to the prosecutor, or if it goes to a lawsuit situation, a judge or a jury to decide whether that person was actually going too fast for conditions. And I think Trooper Atkinson even alluded to the fact that it depends on, the specifics of the community where it happens, whether people generally view that as a true accident or whether it's something that the person should be held liable for, either criminally or civilly. And so I think what Atkinson points out is really what we have here, which is a true fact specific kind of question here and opinion that calls for determination by a fact finder, and that the default position by the troopers based on the conditions and the fact that the defendant lost control is that it doesn't necessarily mean liability in all circumstances and in all under all conditions. So there's that, which in my view gives rise to a question of fact for determination from a jury about whether or not, in light of the fact that the troopers write it up as a loss going too fast for conditions, whether or not it truly was under those circumstances. The other thing is, when you look at some of the other facts surrounding this, the only data that they had from the FJ was that it was going maybe 73 miles an hour, but the testimony as to the EDR results was because of the spinning of the vehicle and so forth. They could never really nail down with any certainty what the speed was, but that was the only number that was available. Trooper Stone at page 26 of his deposition testified that the data they had from the Silverado was that it was going 69 miles per hour. So, was Mr. Smith going too fast for conditions if he was going 73 and the Silverado was going 69? I mean, those are fairly comparable speeds. So even if Smith was traveling slightly faster than the Silverado or other people that he passed on the road that day, how much faster was he going? And is that too fast for conditions when the Silverado was going 60 miles an hour? And so, again, this isn't an assured clear distance issue. This is more in the line of the hitting a patch of ice and crossing the center line issue. And so even in snowy weather and even going at that speed, is it reasonable to expect that Mr. Smith to expect that he was gonna hit ice when he did, when he was going generally at the same speed as other vehicles on the road at that time. Maybe it was, you know, I mean, he was going over an overpass, and there are warning signs on overpasses. And so is it more reasonable to expect that he would hit ice on an overpass? And as I was going through this kind of back and forth in my mind, considering this motion, and I find whenever I'm doing that, when I'm looking at facts, and if I'm going back and forth and I can see both sides of this, what that tells me is that there is a genuine issue of fact here, and that a reasonable person could conclude that Mr. Smith wasn't going too fast for conditions, and that hitting that ice was unexpected at the time that he hit it and in the way that he hit it, given the way he was traveling and the other vehicles were. But I think a juror could absolutely find that common sense says you're going over a overpass in snowy conditions like he was that day. You need to slow down or be ready for possible slippage. So I think jurors could go either way on this, and because of that, I think there's room for a question of fact here. And again, I have to look at everything in a light most favorable to the defense here and the non-moving party. So for all of those reasons, I do find that there is a question of fact as to liability, and in particular whether or not the sudden emergency is a viable defense here. So the court is going to deny the motion for summary disposition. And so, Mr. Drew, as the moving party, I would request that you prepare an order that reflects the ruling of the court today and submit that under the 7-day rule.
Yes, Your Honor. Couple of things, if I may. Is that a decision with prejudice or without prejudice? And the reason I state that is because the defense has been using an affidavit that is not signed and not admissible at this point in time. In fact, the defendant didn't have any admissible evidence that he responded to the motion with, which is required under the court rules, MCR 2.116 C10. And if it turns out that that is not the testimony from Mr. Smith and or the affidavit never becomes signed, I'm wondering if that makes this a situation where your denial would be without prejudice, so that it may be raised again. If not, that's okay. I just am raising the point for clarification.
Sure, yeah, and I guess to clarify my ruling, I'm basing my decision on all of the exhibits that were submitted with plaintiff's motion. I'm not basing it on any of the information that was provided by defense. So I'm going on the deposition testimony that was attached to plaintiff's motion. So
thank you for that clarification.
And I'm not relying on that affidavit. So
very good. Thank you, Your Honor.
okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
Thank you, Your Honor. And just briefly before we disconnect, can the court verify that Mr. Smith is not in the courtroom today?
Mr. Isles is the only person present here with us,
Thank you,
except
Your
for
Honor.
my court officer and the clerk.
Thank you, Your Honor.
Okay.